Since the advent when we were discussing about these acts, especially the BNSS Act 2023, we had requested Mr. S.R Somasekhara, retired Principal District Judge, Bengaluru, Rural District, Karnataka, if he could share his knowledge, and as usual, he readily accepted that. And we know that the way he explains and explores the topic is worth, I will say that it sounds music to the ears and minds. So we are always so pleased to the fact that he is willing to share his knowledge. Thank you, sir, for accepting our invite. And over to you.
Good evening. Thank Mr. Vikas Chatrat again for giving me one more opportunity to speak on BNSS, which has come into force on 1/7/2024. Before I take up BNSS as such, am I audible? Am I audible? Yes. Before I take up BNSS as such, generally about all the three new enactments which have come into force on 1/7/2024, a few words. Now, as far as BSA, the law of evidence is concerned, there is not much of a change at all. There is a provision regarding repeal and savings. It has been, in my opinion, put by way of abundant caution because it says any application, appeal, trial, inquiry pending before the new adenium, before this BSA came into force, shall be held, tried, disposed of in accordance with the Indian Evidence Act. No trial takes place under the Indian Evidence Act, no inquiry takes place, no investigation takes place. It is under CRPC, all that is done. With regard to Bharatiya Nyaya Samhita, which is a replacement of the Indian Penal Code, well, the sections are rearranged. A few acts which are not recognized, which are not found to be offences under the Indian Penal Code, are now made offences. There is again a provision, repeal and savings, in that enactment. Even without that, Article 20, Clause 1 of the Constitution of India would have taken care of it, because if something is not an offence today and it becomes an offence tomorrow by virtue of some statute, the person who committed that act today cannot be prosecuted or punished or sentenced. If X is the punishment today for the offence committed by him, and if tomorrow by an amendment or by a new law, X plus 1 is the punishment, he cannot be sentenced. This is the principle. Now, the changes in BNSS relate to investigation about medical examination, the timeline regarding submission of the medical report by the by the medical officer, procedure to be followed by the courts, and a host of changes are brought. But even then, the core remains the same. So it will not be difficult for us to pick up all the three laws over a period of time. Of course, as far as BNSS is concerned, there are certain areas where there would be certain procedural problems for which may be encountered by lawyers practicing in the criminal side and for judicial officers working in criminal courts. Law is yet to be settled. On first principles, we will have to proceed in the matter. Each High Court is likely to interpret the provision in a particular way. Obviously, what our High Court says would be the law for us. Till then, we can be persuaded by the views of the other High Courts. I will take it up at the end with regard to repeal and savings, because different High Courts have taken different views in that regard. I have my own view in that regard. With regard to other changes also, I have, from my experience as a trial judge, found that this could be the probable way of proceeding with that particular situation. It is too early to expect a case law. It is still 28/7. Only 27 days have passed after the new law took its birth. It is quite possible that the viewers here have a different view of a particular provision. They might be thinking of a different procedure. Well, certainly they are welcome to have it, because each should have his own view. Then it is also possible that amongst the viewers themselves there are different views. Nobody can be found fault with. But so long as these views are in basic conformity with the structure of BNSS or with the structure of CRPC, which is no repeat, there should not be much of a problem. As I said, till such time, each High Court devises, the High Court on its own cannot do it unless a case reaches the High Court. The pronouncement should be on the judicial side only, certainly not by way of a circular or anything. Now, there are number of definitions in CRPC and in BNSS. Not all of them are material. I am only referring to the changes brought, which have some significance. That is why I have titled the topic as important changes brought about by BNSS. The focus is more on the lawyers practicing in the trial courts on the criminal side and judicial officers working in criminal courts. Over a period of time, we have understood what bail means. If an accused is in the custody of the police or in judicial custody, he is released from that custody by the police or by the magistrate, imposing certain conditions if it is a non-bailable offense. As a matter of right, he is released if it is a bailable offense. We have understood what it is. Now, this BNSS gives a definition of it in section 2(1)(b). Bail means release of a person accused of or suspected of the commission of an offense from the custody of law upon certain conditions imposed by an officer, that is obviously a police officer, or court, on execution by such person of a bond or a bail bond. Lawyers practicing in the criminal side know that sometimes the court releases the accused on his executing a personal bond or a self bond. Sometimes the court asks him to offer a surety. So that bond, which is taken by the court from the accused without requiring him to offer a surety, which hitherto we are calling as a personal bond or a self bond, has now been given a definition in section 2(1)(e). Bond means a personal bond or an undertaking for release without a surety. So no surety is required. Then if surety is also offered, if a bond is taken both from the accused and the surety, it is called a bail bond under section 2(1)(d). Bail bond means an undertaking for release with surety. I think this much, these definitions should be sufficient for today's purpose. Then, in the Criminal Procedure Code, we have different categories of courts: executive magistrates, judicial magistrates of second class, judicial magistrates of first class, metropolitan magistrates, chief judicial magistrates, chief metropolitan magistrates, courts of sessions. Now, what is now deleted is metropolitan magistrates and chief metropolitan magistrates, that you will find in section 6. Under the code, earlier, the power of the magistrate to impose a sentence of fine was limited to ₹5,000. Later, it was enhanced to ₹10,000. Now, under section 23(2), 23 subsection 2 of BNSS, the power of the magistrate to impose fine is enhanced to ₹50,000. And there is also a provision for community service. Please have a look at section 23, subsection 2. 23(1), powers of the CJM, except a sentence of death or imprisonment for life or imprisonment for a term exceeding 7 years. That is the CJM's power of sentencing. Power of the judicial magistrate of the first class, imprisonment for a term not exceeding 3 years, or a fine not exceeding 50,000 rupees, or of both, or of community service. So a community service is another form of punishment provided by BNS and obviously referred to in BNSS also. 23(3), a magistrate of the second class may pass a sentence of imprisonment for a term not exceeding 1 year, or a fine not exceeding 10,000 rupees, or of both, or of community service. What this community service is not defined in BNS, which is the penal code, but by way of an explanation in section 23 of the BNSS, community service, I don't say it is an exhaustive definition, at least there is some indication. Community service shall be the work which the court may order a convict to perform as a form of punishment. This is important. So community service which the court directs the accused to perform is also recognized as a punishment, as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. Now we have, under the Juvenile Justice Care and Protection of Children Act, a provision for community service. If the child in conflict with law is found to have committed the offense, then he can be directed to do some kind of a community service. What it is not provided there also. Maybe, well, it has to develop. Maybe he may be required to go to a hospital, cater to the needs of the patients, go to some school, clean the classrooms, attend to something of that kind. Then how to enforce? Now, section 8 of BNS, that is the penal code, says like this, section 8. Section 8. 8(2). In every case of an offense, 8(2)(a) we can omit. 8(2)(b). Punishable with imprisonment for fine or with fine, no. Then 5. 8(5). If the offense is punishable with fine or community service, the imprisonment which the court imposes in default of payment of the fine or in default of community service shall be simple. How long the default sentence has to be undergone on the failure of the accused to perform this community service is also provided there. In fact, I had a doubt as to how this community service can be implemented, because I went through BNSS, I did not get an answer. Well, one judicial officer, quite good, he told me that it is provided in BNS and it is 8(5), it provides for it. Then, with regard to 41 and 41(a) CRPC, we have new provisions, almost a reproduction or reiteration of what is contained in 41 and 41(a), are raised to bar and a host of decisions by and large before the field. Supreme Court long back in a few judgments held that the accused cannot be handcuffed by the police. It is humiliating. It affects his dignity. Of course, even in those decisions, a leeway was given to the police unless it becomes inevitable, in which event the police will take the permission of the magistrate. Now, section 43(3) of BNSS, please have a look at it. Handcuffing is permissible not in all circumstances, but in certain circumstances stipulated therein itself. Section 43, subsection 3, just have a look at it. Section 43 corresponds to 46 CRPC, arrest how made. Then (43)(3), the police officer may, keeping in view the nature and gravity of the offence. It is not that in every case they can handcuff. It is not the police are given a free hand now to handcuff the accused, violating his human rights. In a few circumstances, may, keeping in view the nature and gravity of the offence, use handcuff while making the arrest of a person or while producing such person before the court who is a habitual or repeat offender, or who escaped from custody, or who has committed offence of organized crime, that is defined in BNS, terrorist act, drug-related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins, currency notes, human trafficking, sexual offence against children, or offence against the state. A mere reading of subsection 3 of section 43 would indicate to us that only in respect of a little serious and heinous offences, this handcuffing is permitted. Now, have a look at chapter 6, dealing with process with compel appearance. Now, section 63, clause 2, it provides for service through encrypted or any other form of electronic communication. And it shall bear the image of the seal of the court, obviously. Since it is not a hard copy of the summons, it can only be an image. So, image of the seal of the court and then digital signature. This is section 63, subsection 2. Then we have section 64, subsection 2. The police station or the registrar of the court shall maintain a register to enter the address, email address, phone number, and such other details as the state government may by rules prescribe. Then there is another proviso attached to 64(2), provided that summons bearing the image of the court seal may also be served by electronic communication in such form and in such manner as the state government may provide by rules. Then, in CRPC, unlike CPC, in CPC also the earlier provision was summons can be served only on an adult male member. In 1976, when CPC came to be drastically amended, well, service of summons on any adult member of the family was permissible. Now, in CRPC of 1898 and in 1973 also, service would only be on an adult male member. Now, section 66 of BNSS provides for service on any adult member. It need not be only on an adult male member. This is another important change that is brought. Now, as far as witnesses are concerned, they can also be served through electronic means. Then 70 is important. Section 70, subsection 3 BNSS says, wealth. Service through electronic communication is due service. Therefore, there is no question of anybody contending that there is no personal service of summons on the accused. If through electronic means accused is served and he chooses to remain absent, the court would be justified in issuing a non-bailable warrant or a bailable warrant against the accused, depending upon the situation. Then, straight away we may go to section 105 of BNSS. As I told you in the beginning, I am not taking you through the entire BNSS. It's not possible. Nor all the changes. Some significant changes which are of some consequence, relevance, and need to lawyers practicing in the trial courts or the criminal side and to judicial officers working in criminal courts. Now, section 105, it's an insertion, recording of search and seizure through audio, video, electronic means. So the police during the course of investigation search a place and seize something, that entire process needs to be recorded through any audio, video, electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate, or judicial magistrate to the first class. This is an insertion. Now, here itself, I may refer to section 185, subsection 5 of BNSS. Now, it is altogether in a different context, but to complete the chain, it is better I refer to 185 BNSS corresponding to 165, search by the police officer. Now, section 185 subsection 5 is corresponding to 166 CRPC. With a change there, copies of any record made under subsection 1 or subsection 3 shall forthwith, but not later than 48 hours, be sent to the nearest magistrate, empowered to take cognizance of the offence, and the owner or occupier of the place search shall on application be furnished free of cost with a copy of the same by the magistrate. Then we may take up section 107. This is an insertion in BNSS. It really requires some explanation and complete attention on the part of the audience. I am reading 107 of BNSS. There is no corresponding provision in CRPC. It is an insertion. Marginal note reads thus: attachment for feature or restoration of property. Subsection 1. Where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offense. Well, we need not go into those academic details as to what a criminal activity is and what an offense is. Well, we'll take it as an offense. What is the first requirement? The police officer should have reason to believe that any property is derived or obtained directly or indirectly as a result of commission of an offense or a criminal activity. A commits an offense. He comes into possession or custody of a property. He does not keep it with himself. He delivers it or transfers it, not for consideration or anything, for whatever reason it be, to the hands of B. I am not speaking of a receiver of a stolen property under section 411 IPC, corresponding provision I will have to check in BNS. Now, the property is not in the hands of the accused, but it is now in the hands of the person to whom he has transferred the custody of the property. That is why it says directly or indirectly. He may, that is the police officer, may, with the approval of the superintendent of police or the commissioner of police. So usually in metropolitan cities and other big places, we have the commissioner of police. His counterpart elsewhere is the SP, that is the superintendent of police. With the approval of the superintendent of police or commissioner of police, make an application to the court or the magistrate. Why this court? The reason is we have a good number of penal statutes, the Poxo Act, then Prevention of Money Laundering Act, Prevention of Corruption Act, Atrocities Act, NDPS Act, number of criminal new special enactments. There it is the court. In some enactments, they are called special courts. In some enactments, the expression used is special judge. So it is not as if all first information reports should reach the magistrate, final report should reach the magistrate. So there are a few enactments where the special judges who are usually in the cadre of sessions judges can directly receive the FIR, can also directly receive the final report, that is a charge sheet, without the case being committed by the magistrate under section 209 CRPC. Now the corresponding provision, you find it out. So now the first requirement is the police officer should enter into a subjective satisfaction. He has a reason to believe that a particular property is in the hands of the accused or someone else, and that property is derived or obtained directly or indirectly by committing a criminal act or by an offense. Then he needs the approval of the superintendent of police or the commissioner for proceeding further. After such approval is given, he may make an application to the magistrate of the court, to whom magistrate of the court which can take cognizance, which has jurisdiction to take cognizance, or commit the case for trial. For what purpose? For attachment of such property. So these are preconditions. Now, 107.1 speaks of the powers of the police, preconditions for exercise of that power. Then the role of the court or the magistrate comes, subsection 2 of 107. If the court or the magistrate has reasons to believe, whether before or after taking evidence, it is not evidence during the course of trial. It is some kind of a minimum evidence for dealing with this application under section 107 BNSS, because it is at a stage when the investigation is still going on. Therefore, the word evidence referred to in 107.2 is not evidence which is recorded during the course of trial, that is, after the final report is filed and after the charges are framed. Recording evidence means recording evidence for the limited purpose of dealing with this application, that all or any of such properties or proceeds of crime, the court or the magistrate may issue a notice upon such person, calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. So after the police makes that application, the magistrate, either before taking evidence or after taking evidence, forms or has reasons to believe that the properties which are in the possession of the accused or other person are proceeds of crime, then he may issue a notice to that person. Please see, issue a notice upon such person. It is not stated accused. The reason is, the accused who has committed the criminal activity or the offense might have put it in the hands of someone else. Therefore, the word used is such person. He has to be given a notice to show cause within a period of 14 days as to why an order of attachment should not be made. Subsection 3. Where the notice issued to any person under subsection 2 specifies any property as being held by any other person on behalf of such person, a copy of the notice shall also be served upon such other person. Then subsection 4. So notice is issued to the person concerned. He shares something. What is it that the court has to do thereafter? Subsection 4. The court or the magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2, and the material fact available before such court, that material fact will be in that application, or some evidence which he has recorded, or some documents which the police have produced. And after giving a reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be the proceeds of crime. Well, according to the police, 4 items are proceeds of crime. But the magistrate, after hearing the person in whose possession the property is, may opine that all these properties are not proceeds of crime, but only one of them, or few of them, or none of them. If none of them, you will dismiss the application. If at least 1 or 2, then he may have to pass an order. Provided that if such person does not appear before the court or the magistrate or represent his case before the court or the magistrate within a period of 14 days specified in the show cause notice, the court or the magistrate may proceed to pass the ex parte order. There is no question of issuing NBW or proclamation at this stage. What the section contemplates is a notice to the concerned person before passing an order of attachment. So if he does not avail of the opportunity that is given to him to have his say by answering the notice, then an ex parte order could be passed. There is no question of issuing NBW and securing his presence. Subsection 5. Notwithstanding anything contained in subsection 2, if the court or the magistrate is of the opinion that issuance of notice under the said subsection would defeat the object of attachment or seizure, the court or magistrate may, by an interim order passed ex parte, direct attachment or seizure of such property, and such order shall remain in force till an order under subsection 6 is passed. Those of you who are practicing on the civil side would know that there is what is known as Order 39, Rule 3 CPC. The normal rule is not to grant an interim order of injunction without notice to the defendant. In a situation where the court comes to a conclusion that the object of granting injunction later would defeat the very object of granting injunction, defeat it by the delay in issuing notice, the court may pass an ex parte order. So therefore, though subsection 2 contemplates a prior notice, in a situation where the court thinks that the very object of attachment or seizure would be defeated by issuing a notice, an ex parte order could be passed to remain in force till an order under subsection 6 is passed. Well, again, recall your knowledge of the Civil Procedure Code. An ex parte order of temporary injunction is passed till to be enforced till a particular date. Thereafter, if the defendant appears, the court may, under 39 Rule 4, vary, vacate, and all that order. See subsection 6. If the court or the magistrate finds the attached or seized properties to be the proceeds of crime, the court or the magistrate shall by order direct the district magistrate to ratably distribute such proceeds of crime to the persons who are affected by such crime. So now the role of the court or the magistrate stops at directing the district magistrate to ratably distribute. What the district magistrate has to do after such a direction is received from the court or the magistrate is conspicuously absent in BNSS. Well, we may have to wait for some time. Subsection 7. On receipt of an order passed under subsection 6, the district magistrate shall within a period of 60 days distribute the proceeds of crime. Fine. How? Either by himself or authorize any officer subordinate to him to effect such distribution. Is it by way of sale or what? Nothing is provided there. If there are no claimants to receive such proceeds, or no claimant is ascertainable, or there is any surplus after satisfying the claimants, such proceeds of crime shall stand forfeited to the government. No doubt, the magistrate or the court can direct the district magistrate to ratably distribute. For ratable distribution, the property needs to be sold, how it is to be sold, all those details are not available. Now I am on a totally different point. This is a tentative view of mine based on 2 decisions of the Supreme Court. As I said, it is a new provision. Till the High Court or the concerned High Court or the Supreme Court pronounces upon it, well, only on first principles we will have to understand this. I am emphasizing on the fact that it is my personal view, somewhat guided by 2 earlier decisions of the Supreme Court. You please notice that section 107 of BNSS, which is an insertion, is in the chapter under the title Processes to Compel Appearance. Processes to compel appearance of persons, and there you will find production of things and other things. It is this chapter you find it. Now, 106, the previous section, is power of the police officer to seize certain property. 107 and 106 are found in the same chapter. Therefore, according to me, the pronoun me underlined, that whatever interpretation the court has placed on the word property occurring in section 106 BNSS corresponding to 102 CRPC should, for the present, hold good for property under 107 also. Now, 106 corresponds to 102 CRPC. The Supreme Court in Teesta Atul Settle what? Teesta, T-E-S-T-A. Teesta Atul Settle Ward versus State of Gujarat, 2018, Volume 2, SCC 372. 2018, Volume 2, SCC 372 has held that exercising powers under 102 CRPC, now 106 BNSS, can prohibit operation of a bank account. Police can prohibit operation of a bank account, and a bank account can also be seized. This decision makes a reference to a number of earlier decisions. The relevant ratio you find at para 17 and 18. Well, this may have some incidental bearing on the Criminal Law Amendment Ordinance 1944. Now, under the Prevention of Corruption Act, particularly in cases of disproportionate assets, the provisions of that ordinance, well, though our knowledge of constitutional law says that an ordinance life is only 6 months, it has been held to be a permanent ordinance. In Jayalalitha's case, that is, the Supreme Court has said it by referring to some earlier decisions also. So normally in such cases, the property needs to be attached. Bank account, because the investigating officer, during the course of investigation, prima facie forms an opinion that a particular sum of money, a particular deposit, balance at the credit, or some FDs are all proceeds of an offense committed under the Prevention of Corruption Act. Ultimately, that needs to be confiscated if the accused is found to have committed that offense. Therefore, the Criminal Law Amendment Ordinance has a detailed procedure of attachment. In fact, as the ordinance then stood, the application judge would exercise his powers under the Civil Procedure Code for attachment, Order 21 and other things. And procedure of Order 27 CPC is also contemplated. Now, say there's an amendment to Criminal Law Amendment Ordinance and corresponding amendment to the Schedule to the Prevention of Corruption Act. Now, a special judge under the Prevention of Corruption Act can also exercise that power under the Criminal Law Amendment Ordinance. All this is incidental. Now, I said under 102 CRPC corresponding to 106 BNSS, the police can seize a bank account, can prohibit operation of a bank account. The next question is whether the police in exercise of its power under 102, 106 BNSS can attach an immovable property. In this regard, please refer to Nevada Properties, NEVADA. Nevada Properties Private Limited versus State of Maharashtra. Nevada Properties Private Limited versus State of Maharashtra, 2019, 20, Volume 20, SCC 119. 2019, Volume 20, SCC 119. After a detailed discussion, the Supreme Court has held that immovable property cannot be attached under Section 102 CRPC. However, the documents of title can be seized. Documents of title can be seized. Otherwise, the accused is likely to offer them by way of a mortgage by deposit of title deeds, equitable mortgage, away loan and other things. He may transfer the property. So, keeping that in, documents of title can be seized. Immovable property cannot be attached. Since 107 BNSS finds its place in the very chapter where 106 corresponding to 102 CRPC is found, according to me, till the Honorable Supreme Court gives its interpretation, the interpretation placed by the Supreme Court as to what property can be attached under 102 may hold the field for attachment to the property under 107 also. The next change that is brought is in chapter 13 corresponding to chapter 12, information to police and their power to investigate. Now, under section 154 of the Criminal Procedure Code, if the information given to a police discloses commission of a cognizable offense, they register a case and send the first information report to the magistrate. There is a difference between first information and first information report. Though normally while speaking, we do not make the distinction and generally say FIR, first information is something lodged by a person with the police. Why is it called first information? For the first time from that informant, the police get information about the commission of a cognizable offense. Therefore, it is called a first information. Though loosely we call it as a complaint, complaint both under CRPC and under BNSS is a complaint defined under 2D corresponding provision in BNSS, filed before a magistrate under 200 CRPC. But what is lodged with the police is technically not a complaint, it is a first information. So on the basis of the first information, when a cognizable offense is disclosed, police come to know for the first time that a cognizable offense is committed. They register the case. They have a format. Each state has devised its own format. Those particulars, when the first information was received, under which provision of which law the case is registered, by what time it was received, through which police constable or head constable it has been forwarded to the magistrate, all those details are found or mentioned in different columns. That report is called the first information report and the FIR. Now, its corresponding provision is 173. Here, this first information can be lodged not necessarily within the jurisdiction of the police station where the crime is committed. Now it can be done elsewhere also. Now, practically what was happening is this. The offense has taken place within the jurisdiction of police station X. For whatever reason it be, maybe on account of some convenience or ignorance, the informant not knowing that the offense is committed within the jurisdiction of police station X may go to Y, because he is not aware within which jurisdiction the offense is committed. Two things were happening. Either the police were orally asking him to go to place X, or they would say, well, it is not within our jurisdiction, you search the jurisdictional police station and go, or receive it, and if during the course of investigation it transpired that the offense was committed not within the jurisdiction of their station, but within the jurisdiction of a different station, the procedure generally used to be, at least in so far as Karnataka is concerned, to seek permission of the magistrate to transfer the case to the jurisdictional, to transfer the FIR itself to the jurisdictional police station, which permission, in my opinion, is really not necessary. But normally when something reaches the court, the police do not act without a kind of a permission or a direction or an order from the courts. Now, this 173 provides for receiving that first information, even by a police who have no jurisdiction. This is now popularly called as zero FIR. Well, I am given to understand that some software is being developed, and supposing FIR, first information is registered in police station X, that software itself would detect which exactly is the jurisdictional police, and automatically it gets transferred to the jurisdictional police. Some number is given. Each state may have its own way of numbering such FIRs. That, according to me, well, it has been there. in some form or the other. The next question is, when the first information is registered, or rather received, in a police station which has no jurisdiction, can that police go on with the investigation? Here 173 does not say so. For that, we may have to go to section 175 corresponding to 156. Let me first read 156 CRPC. Police officers' power to investigate cognizable cases. Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable cases which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of Chapter 13. So, Chapter 13 CRPC 177 and onwards, they deal with the territorial jurisdiction of the courts. Therefore, for the police to make an investigation under 156, if the magistrate has jurisdiction over that, the police also get jurisdiction. You will find it in 175(1). Any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provisions of chapter so and so. Therefore, according to me, even if the FIR is registered by a police which doesn't have territorial jurisdiction, further investigation will have to be done. Further investigation will have to be done by the jurisdictional police also. This is my understanding from a combined reading of section 173 and 175. Then, there is something more with regard to this first information. Please have a look at section 107. Of course, subsection 2 says, copy of the first information report will have to be given free of cost, not only to the informant, but also to the victim. So this is one insertion. And then subsection 3 of 173 is an insertion. Please have a look at it. Without prejudice to the provisions contained in section 175. Therefore, 173 cannot be read in isolation. We will have to read 175 also. I will go to 175 a little later. Without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more. Please see these conditions. The offence should be punishable for 3 years or more, but less than 7 years. The officer in charge of the police station may, with the prior permission from an officer not below the rank of Deputy Superintendent of Police, considering the nature and gravity of the offence, proceed to conduct a preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in a matter within a period of 14 days, or proceed with investigation when there exists a prima facie case. By now, most of the lawyers, I believe, practicing on the criminal side seriously would have known this decision of the Supreme Court in this famous Lalita Kumari versus Government of Uttar Pradesh. Lalita Kumari versus Government of Uttar Pradesh, reported in 2014, Volume 2, SCC 1. To understand the change brought about by 173(3), we may have to read at our leisure this Lalita Kumari's case. There were contrary views earlier. In some cases, the view taken was, it is not that merely because the first information discloses some cognizable offence, the police should immediately register the case and proceed. Some kind of a preliminary inquiry may also be made. The other view was, going by the plain language of section 154, where the first information discloses the commission of a cognizable offence, police have no option except to register the case and proceed further. In view of these conflicting views, the matter was referred to a larger bench. The decision of the larger bench is in this Lalita Kumari. Lalita Kumari has said, yes, if the first information discloses the commission of a cognizable offence, police have no option except to register the first information report and submit to the magistrate and take up investigation. That said, they also carved out some exceptions that you find in the last para of the judgment, 120, as I stand corrected, penultimate para 120, conclusions and directions. It says, registration of FIR is mandatory and no preliminary inquiry is permissible if the first information discloses. If the information does not disclose a cognizable offence but indicates the necessity for an inquiry, preliminary inquiry may be conducted only to ascertain what? Whether a cognizable offence is disclosed or not. Not to go into the question whether any offence is committed or not. No. Whether the first information discloses commission of a cognizable offence or not, only to that extent, preliminary inquiry is permitted in this Lalita Kumari. And the Supreme Court has also given a small list of the cases where this preliminary inquiry may be needed. That is in para 120.6. As to what time and in which cases preliminary inquiry is to be conducted will depend on the facts and circumstances of each case. The category of cases in which preliminary inquiry will be made are as under: matrimonial disputes, family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is abnormal delay or laches in initiating criminal prosecution. For example, over 3 months delay in reporting a matter without satisfactorily explaining the reasons. And so preliminary inquiry is to be confined only to find out whether the first information discloses commission of a cognizable offence or not. Now, in subsection 3 of 173, what we find is, if the offence is punishable for 3 years or more, but less than 7 years, then the police officer, with the prior permission of an officer not below the rank of DYSP, then again considering the nature and gravity of the offence, needs to make a preliminary inquiry, not just to find out whether the first information discloses a commission of a cognizable offence, to find out whether there exists a prima facie case, and any such inquiry has to be made within a period of 14 days. If he finds that there is a prima facie case, he has to proceed with the investigation. Now let us go to subsection 4 of 173, which corresponds to 154.3. 173.4 corresponds to 154.3 with some change. First, let me read 154.3. Any person aggrieved by a refusal on the part of an officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who is satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in a manner provided by this code, and such officer shall have all the powers of an officer in charge of the police station in relation thereto. So normally when the station house officer or the jurisdictional police did not act, some kind of a representation in writing used to be given to the SP. If he finds that there is cognizable offence, will either investigate the case. Normally they don't do it. They direct an investigation to be made by any police officer subordinate. Now this 173.4 goes one step further. Instead of reading the entire thing to save time, I am reading only the last few lines. failing which such aggrieved person may make an application to the magistrate. If the superintendent of police also does not act, then a remedy is provided to the informant to file an application to the magistrate. Here is the problem, a procedural problem. Then 173(4) provides for a remedy to approach the magistrate with an application. What is it that the magistrate has to do after receiving that application has not been stated in 173. This is certainly an area which requires some kind of an interpretation, procedural, how to go about this by superior courts. But for the matter to reach the superior court, magistrates, when they receive such application, have to pass an order applying some basic principles of natural justice, their own knowledge of fundamentals of criminal procedure. Well, that needs to be done. Lawyers also will have to equip themselves for this new situation because for them also it is new. They may also have to do it. Well, over these 26 or 27 years, 27 days, if some courts have already dealt with such application, may not be our own high court, some other high court also, that could also persuade the magistrates of your state to go to follow that procedure till your own high court deals with this. So now we can't say no, let our high court decide, till then we don't make an application. Nor a judicial officer says no, there's a new procedure, there's no provision as to what is to be done. No, as I said, it stops there. Then go to the next section. Here, 175, that is 156, which I already read out. 156 has 3 subsections. 175, 1 to 3 are those 156 to 1 to 3. Some there in subsection 3 of 175, there is a slight change. I don't say it is a slight change, it's a significant change. Please keep 156.3 also. Juxtapose it with 175.3. I'll first read 156.3. Any magistrate empowered under section 190 may order such an investigation as above mentioned. So you know this basic principle that a cognizable offense is one in which a police can arrest without a warrant from the magistrate, that is as per the definition. As if you carefully go through these provisions relating to information to police and their powers to investigate, you will know one more distinction. A cognizable case is one in which the police can investigate without a direction from the magistrate, while a non-cognizable case is one where they need that direction. Keep that in view. Now, a magistrate can also direct investigation under 156.3. Which magistrate? A magistrate empowered under 190. This 190 is now 210 BNSS. Now I am reading 175.3 BNSS. Any magistrate empowered under section 210. Now see the change here. May, after considering the application supported by an affidavit made under subsection 4 of 173, considering the application supported by an affidavit made under subsection 4 of 173. You will find subsection 4 of 173 does not refer to any affidavit. It only refers to an application. Actually, the wording should have been, may after considering the application made under subsection 4 of 173 supported by an affidavit. But if you read it as it is, you get an indication that 173.4 also provides for an affidavit. No, it only provides for an application. Now see this. Any magistrate empowered under 210, that is 190, may, after considering the application supported by an affidavit made under subsection 4, obviously it's an application made, not affidavit, and after making such inquiry as he thinks necessary, and submissions made in this record by the police officer, order such an investigation as above mentioned. Here is a little difficult task for all concerned. Well, I do not know how far I am right. I am telling all this with a caveat and a rider. Most of you practicing on the criminal side would have known of this decision in Priyanta Srivastava versus State of Uttar Pradesh. Priyanta Srivastava versus State of Uttar Pradesh, 2015, 6 SCC 287. 2015, 6 SCC 287. That was a case where a bank had lent money to certain people. Instead of repaying the loan, the borrowers went on filing police complaints, private complaints against bank officials, saying that they had forged documents, cheated them, defrauded them, and all that. Number of complaints. Ultimately, the matter reached the Supreme Court, and Supreme Court said, we have now reached a stage where in a private complaint, we should insist on an affidavit saying that the complainant had approached the superintendent of police as provided under 154. No action was taken. All those details should be given by way of an affidavit. I am not very sure whether this Priyanta Srivastava was in view when this BNSS was drafted to make a mention about this affidavit in subsection 3. But subsection 3, as I said, refers to 156.3, investigation by the magistrate. Now, what has been the procedure throughout, at least insofar as Karnataka is concerned, is a private complaint used to be filed under 200. If it did not disclose any offense, right away the complaint would have been dismissed. If it disclosed some offense, the magistrate had two options. Either to record the sworn statement under 200, register the case, or after recording sworn statement, he finds that no case was made, dismiss the complaint under 203. Or if he finds that for some more material is required, postpone issuance of process and make some kind of a further inquiry or investigation under 202. This is the procedure. Supposing the magistrate thinks, well, it is not a case where he can do anything. It's a fit case for investigation by the police. He would make a reference 156.3. That is the procedure, to my knowledge, in the state of Karnataka. Elsewhere also the same procedure may be there. I have read some judgments of high courts and the Supreme Court, in fact, this Priyanta Srivastava itself, which would give an indication that a petition under 156.3 CRPC itself is filed before the courts concerned for referring the matter to the police. Here in Karnataka, no separate application or petition is filed under 156.3. A private complaint under 200 is filed. The court in its discretion either proceeds on its own or refers it. Sometimes the lawyers appearing for the complaint themselves make a submission. This may not be a case where the court can have collect material and proceed. It is a fit case for investigation by the police. They don't make a separate application. As I said, some decisions relating to cases coming from northern parts of the country would indicate that a petition is filed into 156.3. Therefore, maybe it is in this context, an application supported by an affidavit in the context of Priyanta Srivastava. Now, the problem here is this. Under 156.3, the magistrate would have directed investigation by the police. Well, the police would file report, final report, thereafter a detailed procedure. Now there are some constraints here. For the magistrate to act under 175.3, there are certain requirements, as I said, an application referred to in section 173, accompanied by an affidavit, not referred to there, but presumed to have been referred to there. And then it doesn't stop there. Even to make that an inquiry as he thinks necessary and submission made in this regard by the police officer. Therefore, that police officer also has to be heard before the magistrate directs an investigation in this regard. Well, this is certainly an area which has, whether this petition under 175(3) has to be registered as a separate miscellaneous petition or in a private complaint under 200 its corresponding provision, the court can do. They are all matters for procedure. My only advice is, it is still too early for us to think of a procedure. Well, let us remember that saying, procedure is only a handmaid of justice and not the mistress of justice. The basic thing is principles of natural justice have to be followed. Well, if there are certain statutory provisions, they need to be followed. I cannot have a final say in this regard. Each of you may have your own opinion. Over these 27 days, magistrates would have passed orders on those applications. Lawyers would have found out some way of dealing with those applications. Anyway, to me, it appears it may have some foundation in the context of this Priyanka Srivastava's case. Then go to subsection 4. Any magistrate empowered under 210 may, upon receiving a complaint against a public servant arising in the course of the discharge of his official duties, order investigation subjecting to receiving a report containing facts and circumstances of the incident from the officer superior to him. So if a private complaint is filed against a public servant, then before proceeding further, the magistrate has to call for a report from the official superior of the public servant, and after consideration of the assertions made by the public servant as to the situation that led to the incident solely. So it contemplates a report from his official superior, and indirectly it contemplates an opportunity to the public servant also to do it. Do not confuse this for sanction for prosecution under 197. It's a different section now here. 197 contemplates a sanction for prosecution, a prohibition against the courts from taking cognizance without a sanction. Here it is a kind prior to investigation itself. This is the requirement. This is another change which is brought about by BNSS. Now, this may not be of much relevance to the judicial officers and lawyers. 184 BNSS is 164A CRPC, medical examination of the victim of a rape. Subsection 6 now requires that the medical officer who makes that examination has to give his report within 7 days. Maybe the investigative police officers will have to bring this to the notice of the medical officers concerned that there is a change in the law now. They are required to give that report within 7 days. Well, then another important change. 193, which is 173 CRPC final report. Subsection 8 of 193, subsection 8 of 193 now provides for supply of that final report in the documents by electronic communication, and it shall be considered as due service. So that is sufficient. Then one very significant change with regard to further investigation under 173(8), which corresponding provision is 193(9). For those who are novices and uninitiated, something about this further investigation, which is seen in 173(8), corresponding provision is 193(9). The leading decision on this point is Ramlal Narang versus State Delhi Administration. Ramlal Naren versus State Delhi Administration. AR 1979 Supreme Court 1791. AR 1979 Supreme Court 1791. Also reported in SCC 1979 to SCC 322. From 1979 till 2019, over a period of 40 years, there are a number of decisions. This Ramlal Naren makes a reference to the Law Commission report, either 42nd or 44. I have just forgotten it. The Law Commission said police always had the power to make a further investigation even after submission of the final report. But it is the courts which took a narrower view that once the final report is submitted to the court, the police could not make any further investigation. The Law Commission recommended, saying it has now become necessary for us to clarify by inserting a separate section recognizing the powers of the police to make further investigation. Those of you who are well versed on the civil side would know that 151 CPC does not by itself confer inherent powers on the court. It only recognizes the power which was already in the court. By the very establishment of a civil court, certain powers inhered in it. 151 has only recognized it. Similarly, 173(8) has recognized the power of further investigation which the police had, but the courts felt that they could not do it. This is a brief history about it. Now, what is the change brought about in this regard here? This 193(9) is 173(8) with a slight change by way of a proviso. Provided that further investigation during the trial may be conducted, with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. For how long it could be extended is not stated, at least for a period of 90 days. There are certain significant things here that further investigation during the trial may be conducted with the permission of the court. When the trial commences, how, they are all matters for interpretation. This is not the occasion to go into details. Just know it that any kind of further investigation during the course of trial can be made by the police only with the permission of the court, and the time limit is 90 days for completion of that further investigation, which could also be extended. Now, with this Ramlal Naren, what the Supreme Court said is, well, police always had the powers. A formal permission may be sought for the magistrate because, since the matter has already reached the court, it is only necessary to uphold the majesty of the magistracy. A formal permission will be asked. Well, as a matter of course, that permission is to be given. Well, how that further investigation can it be triggered at the instance of the court itself? What could be? They are all matters for judicial interpretation. We have got number of decisions. There is no time to deal with all that. Now, there is one more thing with regards to sanction under 197 CRPC. Now, the corresponding provision for sanction is 218 BNSS. 218 BNSS. To prosecute public servants and judges, 197 CRPC contemplated prior sanction of the competent authority. The case laws are the competent authority is the person who can appoint, any person who can appoint also has the power to dismiss. He is called the disciplinary authority in service rules. Well, at what state this sanction could be insisted, they are all covered by a good number of decisions. It is not the time for me to deal with that. Now, ultimately, as per CRPC 197, if the investigating officer wrote to the competent authority for according sanction, within what time that sanctioning authority had to deal with that requisition or request was not provided at all by 197 CRPC. Years together, a writ of mandamus could lie. All these are questions. In some case, the Supreme Court, in the context of Prevention of Corruption, had said at least within 3 months, something of that kind. Now there is a welcome change in this regard. Now this 218 subsection 1 second proviso says that the decision will have to be taken by the sanctioning authority within 120 days from the date of receipt of the request. In failing, it should be deemed sanction. It is really a welcome change because investigating officers were submitting the report, were making a request to the sanctioning authority. For years together, no sanction was accorded. Now, the maximum time is 120 days from the date of receipt of the request, failing which it's a deemed sanction. It is certainly a welcome change. Now, there are a few things. Let me just clarify it before I go to trial aspect of it. Now, 167 CRPC is 187 BNSS. This needs some clarification. Well, many lawyers and judges who are well versed in criminal procedure code have already spoken. Number of lectures are available in the YouTube. Now there is some misconception or misinformation that 187 BNSS provides for police custody beyond a period of 15 days. No. Even now, the maximum period of police custody is 15 days. But what is the change brought? For that, a bit of judicial history is required. Carefully read 167 CRPC at your leisure. A literal interpretation of section 167 nowhere suggests us that this period of 15 days should be within the initial 15 days. Let us say on 29/5/2024, accused was produced before a magistrate. The maximum period of police custody is 15 days. 167 by itself nowhere says that it should be within the first 15 days. Total custody is only 15 days. The first decision on this point is CBI versus Anupam Kulkarni. CBI versus Anupam Kulkarni, 1992, 3 SCC 141. 1992, 3 SCC 141. What the Supreme Court said in this decision is 167 CRPC indicates that this 15 days of police custody can be only during the initial 15 days. Further, it said, if within that 15 days, first 15 days, the police on the first day or on the second day did not require the accused for their custody, subsequently also they could make a request to the magistrate to give the accused into their custody. So therefore, Anupam Kulkarni said, within the first 15 days, there could be interchange of custody, police custody to judicial custody to police custody. I said that on 29/5/2024, accused was arrested and produced before the magistrate. As per this Anupam Kulkarni, from 29/5 to 15 days, it would get somewhere near 12/6 or 13/6 of 2024. Only during that first 15 days, from 29/4 to 12/6 or 13/6, the police would have him for his custody. Then the next decision is, that is 31 years later, 2023, 6 SCC 49, 2023, 6 SCC 49, CBI versus Vikas Mishra. CBI versus Vikas Mishra. See, in this case, the CBI court gave 6 days custody to CBI. Accused was given to the CBI's custody for 6 days. Accused got admitted to the hospital. Therefore, the CBI could not have him for his custody during the first 6 days, lost. Then some interim bail, regular bail, that way. For the first 15 days, CBI could not have the custody at all of the accused. Ultimately, when the matter reached the Supreme Court said that this Anupam Kulkarni needs reconsideration. So here is a case where the accused did not allow himself to be taken to police custody. Therefore, the police could not investigate at all. Therefore, they did some justice in that case, saying, all right, 6 days are already lost, deducted. We will give the accused to your custody for 4 more days, do whatever investigation you want. The next landmark is 2024, 3 SCC 51. 2024, 3 SCC 51, Senthil Balaji versus State. It is a fairly long decision. For our present purpose, you may refer to the last paras. In Senthil Balaji, it is said that nowhere section 167 CRPC says that the police custody should be within the first 15 days. It further said, we have already said in Vikas Mishra 2023 SCC 49 that this decision in Anupam Kulkarni, which said first 15 days, requires reconsideration. So if you have this judicial precedence in background, you will be in a better position to appreciate the change brought about by 187. At the cost of repetition, I am telling that even now, the maximum period for which the accused can be given to police custody is 15 days only. But Anupam Kulkarni, which said that it should be within the first 15 days, is now not there. What is that change brought? For that, you need to know that concept of default bail. Under 167, in respect of certain offences, if the final report is not filed within 60 days, then the accused as a matter of right is entitled to bail. In respect of certain offences which are more serious, 90 days is the maximum. Now they have linked the 60 and 90 days period for the police custody also. It is, don't think that 60 days police custody or 90 days police custody. It is 15 days only. Where do you get it? Please go to that particular section, 187. Subsection 2. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days. Even now, it is 15 days only, in the whole or in parts. At any time, during the initial 40 days or 60 days, out of the detention period of 60 days or 90 days, as the case may be, as provided by subsection 3. Well, there are certain issues which might arise, which the superior courts have to take a call and interpret. Now, within the first 15 days, the police do not move for police custody. Accused makes an application for bail. The court grants bail. The accused is enlarged on bail. After first 15 days, if the police require him for police custody, can the court issue a warrant and secure him? Well, if he is in judicial custody when bail is not granted, maybe. But if he is already enlarged on bail, can he still be given to police custody is certainly a matter of debate, which is not covered by the statutory provisions. Obviously, we will have to wait for decisions of the concerned high courts and the Supreme Court. This is another thing which we will have to mind. Here again, there is some misconception. See, many think that this period of 60 days and 90 days is the period available for the police to file charge sheet. What the 167 or corresponding provision 187 says is, if within 60 days or 90 days final report is not filed in respect of certain categories of offences, accused as a matter of right is entitled to bail. It does not mean that the maximum period within which the charge sheet has to be filed, court can tell cognizance is only this. That period of limitation for taking cognizance is not covered by this. It is in a separate chapter. Now in BNSS, it is chapter 38, limitation for taking cognizance of certain offences. So depending upon the punishment, the period is spread. So therefore, let there be no confusion that the 60 days and 90 days is for completion of investigation. And if it is not filed within 60 days or 90 days, the court cannot proceed at all. There is a separate provision governing limitation. See, in respect of some special enactments, maximum period within which the police have to submit the final report is provided. If they do not do it, well, maybe consequences in some enactments is statutory bail. Well, it doesn't mean that the further investigation needs to be stopped or nothing can be done. Court cannot do it at all. This is one clarification which you may keep in mind. Now, there are a few more things. I will just go a bit quickly and complete it. We have in the CRPC and also in BNSS 4 kinds of trials. Summary trials, though the order is sessions trial, warrant trial, summons trial, and summary trial. I'm going in the reverse direction. Summary trial, chapter 100, chapter 22, BNSS, it is chapter 21. Now, a list of offences which can be tried summarily is provided in chapter 21 CRPC. There is some change brought about in BNSS in chapter 22. Time is not sufficient for me to go in that. I will have to go on about this presentation also in a summary way and closing. And therefore, there's nothing much to apply. It doesn't require any application of mine. Just look at the provisions, you will know which are those offences which can now be tried summarily. What is of significance is this. Summons trial, chapter 21 BNSS, which is chapter 20 CRPC, as those of you who are practicing the criminal side would know, in a summons trial, there is no stage for discharge of the accused before the charge is framed as per CRPC. In fact, the Supreme Court, long back in 92, I'm searching for the citation, I am not getting it. I had made a note of it, I am not getting it. In some Matthews case had said, absence of a provision should not come in the way of the court in closing the proceedings. When the charge sheet papers do not disclose an offence at all, there is no point in going on with the trial. A larger bench, however, took a different view. When there is no provision, there is no question of closing the proceedings. There cannot be a halfway closure. Accused has to plead guilty. If he pleads guilty, end the proceedings by convicting him. If he does not plead guilty, trial has to take place. Now, there is a welcome amendment to this provision regarding summons trial. For want of time, I am not referring to the sections. Just take it. Now, even in the case of a summons trial, if the court finds that there is absolutely no material, it can release the accused. The word used is the order that the magistrate has to pass is releasing the accused. And what is the effect of that order? The effect of that order is it amounts to discharge. Anyway, I just refer to that provision and be done with it. That provision is chapter 22. Chapter 22 CRPC. (274) is 251. There is a proviso. Provided if the magistrate considers the accusation as groundless, he shall, after recording the reasons in writing, release the accused, and such release shall have the effect of discharge. So, actual order that the magistrate has to pass is the accused is released, and it will have the effect of discharge. It is something like Order 21, Rule 92 CPC. The sale is confirmed by the magistrate, Rachan sale. He doesn't make it absolute. Statute makes it absolute. After confirmation of the sale becomes absolute. Here, the magistrate, the order that he is required to pass under this proviso is the accused is released as the accusation is groundless. Take it. No application is required by the accused under 274 for getting release. If he finds it, fine. Even if he does not find it, if the court or the magistrate thinks that the accusation to be groundless, he will have to give reasons and release the accused, and that release will have the effect of discharge. Now, in this warrant trial and sessions trial, under CRPC, rather CRPC does not require an application to be filed by the accused for discharge. However, the practice throughout has been to make an application under the relevant relating to warrant trial and sessions trial seeking discharge. Objections are filed by the state, arguments are heard, and a detailed order is passed. In fact, the Karnataka High Court held in one decision, no application is required at all because the reading of those provisions would indicate that the accused has a right to be heard and the court has got a duty to hear. When the accused has a right to be heard and the court has got a duty to hear, where is the need for making an application? All said and done, applications were filed, objections were filed, arguments were heard. Now, both in sessions trial and in warrant trial, there are enabling provisions enabling the accused to make an application. Please understand, it is only enabling provision. It does not mean that the accused is bound to make an application for discharge if he wants discharge. Because the other provision in CRPC which says, if the court considers the accusation to be groundless, it shall discharge the accused, still remains. Additional thing is an enabling provision. The accused can also make that application. Now, if the accused does not make an application, the court cannot say, you have not made an application and frame the charge. Still, the court is required to apply its mind and find out there are grounds to frame charge. Please be very clear about this. It is only an enabling provision. Enabling provision means, all right, you can avail that. Merely because the accused does not make an application, automatically a charge cannot be framed. There are some minor changes here regarding within what date that order has to be passed and all that, when that application has to be filed. In the case of a sessions trial, within a prescribed time from the date on which the order of committal is passed by the magistrate. In the case of warrant trial, within a prescribed time, within which the after copies are served. So they are all matters for detail. I don't think that they need to be highlighted by reference to those provisions. There is one thing with regard to this trial in absentia. This is 356 BNSS. It is an insertion. Of course, the title as such doesn't say, marginal note doesn't say trial in absentia. It reads this 356 BNSS. Here, inquiry, trial, or judgment in absentia of proclaimed offender. Please understand that this 356 is in chapter 26 BNSS with the title General Provisions as to Inquiries and Trials. Its corresponding provision in CRPC is chapter 24. Now, in the previous chapter, chapter 23 in CRPC and chapter 25 in BNSS, we have a provision for recording the evidence of a prosecution witness in the absence of the accused. That is 299 CRPC. Now it is 335. To understand the scope, the magnitude, and the dimension of this new 356, we must first know in which chapter it is found. 356 is in a separate chapter, a different chapter, the title, General Provisions as to Inquiries and Trials. Whereas 299 and 335 BNSS, they are found in the chapter regarding evidence in inquiries and trials. Now, whether it is under 299 CRPC or 335 CRPC, the court cannot pass a judgment. It can only record the evidence of the prosecution witnesses in the absence of the accused. Both CRPC and BNSS provide that a criminal trial has to take place in the presence of the accused unless his presence is exempted for some reason. Now, this 299 and 335 provide if there are no prospects of getting the accused, instead of keeping the case pending, the court can record the evidence of prosecution witnesses in their absence and seek the permission of the principal sessions judge or the High Court for transferring the case to a long pending register. Each High Court has its own criminal rules of practice, some as to how it is to be done are contained therein. Now, what is that object? You will have to read section 33 of the Indian Evidence Act, some 31 or so of BSA, which says, if a person is already examined in a previous stage of the same proceeding, subsequently he dies, or he is not available, he has absconded or not available, or he is not able, 3 years I always say, alive, able and available. Then only a person can be called as a witness to the court. He has to be cross-examined. If for some reason he cannot be called to the court for cross-examination, his statement is a relevant piece of evidence. Whether on that basis a suit can be decreed and accuser can be convicted, they are all matters for appreciation of evidence. There is a provision. So you will have to read this 299 along with 33 of the Indian Evidence Act. Remember, the court cannot pass a judgment in a proceeding under 299. It has only to record evidence, keep it, send it to the long pending register if the relevant criminal rules of the practice of this provide for it. Now, subsequently, maybe 10 years, 12 years, 5 years, 6 months thereafter, the accused is raised by the police. Those witnesses who have been examined prior in his absence have to be recalled for cross-examination or maybe for the identification of the accused. Supposing they are not able to come, they are not available, they are not alive, their evidence can be used against the accused. Accused cannot complain, I was not given an opportunity to cross-examine. He deprived himself of that opportunity by remaining absconding. So therefore, he cannot now make a complaint. So that evidence can be used, evidence which is recorded in his absence can be used against him. Well, case might end in acquittal or conviction. It's a different aspect of the matter. Now, what is this 356? It is not as if this judgment can be passed in all cases under 356. There are so many riders. First thing, as per subsection 1, I have no time, therefore I'm going a little fast. Notwithstanding anything contained in this Sanhita or in any other law for the time being in force, when a person declared as a proclaimed offender, whether or not charged jointly. So, who can be declared as a proclaimed offender is contained in section 84 of BNSS. So, first let us go to 84 BNSS. I am avoiding the corresponding provisions of CRPC for want of time. I am only referring to because more or less they are similar. So 84 BNSS, proclamation for persons absconding, procedure to be followed, publication to be made. Subsection 4 of section 84 BNSS is important. Where a proclamation published under subsection 1 is in respect of a person accused of an offence which is made punishable with imprisonment of 10 years or more. First requirement is the offense should be punishable with imprisonment for 10 years or more, or imprisonment for life or with death under the Bharatiya Nyaya Samhita, or under any other law for the time being in force, and such person fails to appear at the specified place and time required by the proclamation, the court may, after making such enquiry as it thinks fit, pronounce him a proclaimed offender and make a declaration to that effect. It is not that merely because a proclamation is published, he becomes a proclaimed offender. So an accused can be pronounced as a proclaimed offender only if the offense is punishable with imprisonment up to 10 years or more, life imprisonment, death sentence, and the court has to make some inquiry, and he should have remained absent despite publication of the proclamation. Now come back to 356. Notwithstanding anything contained in this Samhita or in any other law, when a person declared as a proclaimed offender, declared under section 84, whether or not charged jointly has absconded to evade trial, so he has absconded with an intention to evade trial, and there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person. So he has remained absconding, he is a proclaimed offender. Then he cannot comply. Well, I should have been tried in person, not in my absence. And the court shall, after recording reasons in writing, reasons also have to be given, in the interest of justice, proceed with the trial in the like manner and with the like effect as if he was present under this Samhita and pronounce the judgment. Then, provided that the court shall not commence the trial unless a period of 90 days has elapsed from the date of framing of the charge. What does that mean? When will we frame charge? Only when the accused is before us, either through video or physically. So without the accused being secured, either in person or through video, there is no question of framing charge. So therefore, 356 is totally different from 335, that is 299. So charge is to be framed. Subsequent to the charge, these things would happen. Then we'll have to wait for a period of 90 days. Then subsection 2 says, consecutively, warrants will have to be issued within some interval and all that. Relatives will have to be informed. Proclamation has to be published. Subsection 4 is important. Where the court competent to try the case or commit for trial has examined any witnesses for prosecution and recorded their depositions, such depositions shall be given in evidence against such proclaimed offender on the inquiry into or in trial for the offense with which he is charged. Proviso is important, provided if the proclaimed offender is arrested and produced or appears before the court during such trial. So trial has gone on in his absence. He has waived his right of being tried in person under the previous provision. The court may, in the interest of justice, allow him to examine any evidence which may have been taken in his absence. Please be careful. It is not a provision for examining any witness by recalling him. Examine any evidence. Well, this is the evidence recorded in your absence. Go through it and make your submission. Well, whether this evidence is not sufficient to hold you guilty or not. So there is no question of recalling this. This is an improvement, right? Then subsection 5 says this recording may preferably be done by through mobile. And then subsection 6 says, if the accused has voluntarily chosen to remain absent during the course of trial, that will not prevent the court from continuing with the trial and pronounce judgment, even if he is arrested and produced or appears at the conclusion of the trial. Here you may draw a parallel to the provisions of Order 22 CPC. Now, after the arguments are closed in a civil case and the matter is reserved for judgment, during that interregnum, the plaintiff or the defendant or the appellant or the respondent dies. There is no abatement. The court can still proceed with the judgment. But if before arguments are heard, any of them dies, well, application is to be filed for bringing LRs and other things. So similarly here, if the trial has been commenced in the voluntary absence of the accused, the court can continue the trial, pronounce the judgment, even if he is arrested. Now I am ready with the judgment. Trial is ready. Trial has gone on. Judgment is ready. Today he suddenly appears. No, I can still pronounce the judgment. This is certainly an improvement. Then, an appeal lies against this, but there is a time limit. No appeal shall lie against the judgment entered under this section, judgment under this section, unless the proclaimed offender presents himself before the court of appeal. He can't simply file an appeal before the appellate court. He will have to be physically present before the appellate court by preferring an appeal. That appeal against conviction will have to be filed, shall lie after the expiry of, no appeal shall lie after the expiry of 3 years. So we can't go by the provisions of Limitation Act regarding appeal. The period is 3 years, fairly a long period. The state may by notification extend the provisions of this section to any absconder mentioned in subsection 1. That provision is made. Now, with regard to these private complaints, Chapter 16 of BNSS, Chapter 15 CRPC. Well, this is certainly an area which is troubling most of the trial judges and the lawyers practicing on the criminal side. Police have nothing to do with this. Please have both CRPC and BNSS to understand this. Let us first go to 200 CRPC. The corresponding provision here is 223. CRPC. A magistrate taking cognizance of an offence on complaint means a private complaint, shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Let us see 223 subsection 1. A magistrate having the jurisdiction, so territorial jurisdiction is it, while taking cognizance, this word while is now inserted, while taking cognizance of an offence or complaint shall examine on both the complainant and the witnesses present. Rest of it is a reproduction of 200. Now, those of you who are well versed in criminal law would be knowing there were decisions for the proposition that going by the language of section 200, the act of taking cognizance precedes recording of the sworn statement. First, the magistrate has to say, periodically complaint, cognizance taken, case posted for recording sworn statement. There are some decisions, at the end it could be done. We need not worry about this. Now it says, while taking cognizance. That means the magistrate is in the process of taking cognizance, not immediately after the complaint is filed. Thus far, no problem. The problem lies with the proviso to subsection 1 of 223. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. This is unheard of so far, unheard of in criminal law. The basic principle in criminal procedure is an accused has no right to be heard till cognizance is taken by the court. Only when summons is issued, he enters the scene. Even when he is arrested, only with regard to his entitlement for bail or police custody or judicial custody is heard, not beyond that. In a matter of proceeding with the case, there is no question of hearing the accused. Now, this 223 BNSS says, on a private complaint, if the magistrate wants to register the case against the accused has to be heard. No cognizance shall be taken without giving the accused an opportunity of being heard. What is this opportunity? Necessarily, a notice has to be issued. Now, the notice is served to the accused. He does not turn up. The magistrate cannot issue NBW proclamation and other things. The provision contemplates an opportunity. Opportunity means issue of notice. The usual police serve that notice. Supposing the notice is returned as an endorsement, that the accused is not in the address, left the address mentioned in the complaint, it's a private complaint. The complainant has to be given some reasonable time to furnish the address. If he fails to do it, the magistrate has no option except to dismiss the complaint for default. Now, a number of occasions notice is sent. It is not returned with an endorsement that it is incorrect address or incomplete address or he has left it. When the police went there, he was not there. What does it indicate? On 2 or 3 occasions, such notice has been given, sent. He is avoiding to take that. In fact, in the context of 138 of the NIR, the Supreme Court has said, if notice is sent to the last known address of the accused, that is deemed service. Maybe in such a situation, depending upon the endorsement made by the police, the magistrate may say, enough and more opportunity is given. The next question is of some significance, which is not provided by the code, and so far we had no occasion to apply our mind. What is it, that opportunity that we are giving? When an opportunity is given, certainly the person has a right to say something. It doesn't say whether he should file a written objection or make an oral submission. All right, let him do whatever he is. If sworn statement is already recorded, there is no question of permitting the accused to cross-examine them. No, nothing. The accused appears after this notice, serve a copy of the complaint and the sworn statement which the magistrate has recorded, give it to him, give some reasonable time, go through the complaint, documents if any produced, the sworn statement that has been recorded. Please tell me whether there is a case to go for, to take for cognizance. Well, a question would arise whether really at this stage, the accused can convince the magistrate that there is no scope for taking cognizance. As I said, it is for the first time we are seeing such a provision, and therefore we do not know what kind of objection the accused would file, what kind of submission. But to my mind, I have just contemplated some 2 or 3 situations. It's all some thoughts which have come to me over the last 1.5 months. Let us take a simple case. A private complaint is filed alleging that the accused committed some offense on a particular date, at a particular time, at a particular place. Some offense of negligent driving, drunken driving, or some quarrel and all that. Now, a public document is produced by the accused pursuant to this notice, which clearly discloses that he could not have been present at that place on that day at that time. That Newton's laws, 2 things cannot occupy the same place at the same time. A person cannot be at 2 places at the same time at a given date. There a question would arise whether the time was sufficient. Let us say the offense is alleged to have taken place at 5 p.m. That person was found to be at a different place by 11 a.m. Depending upon the distance, it is possible for him to come. I know it's a clear piece of alibi which requires trial. But now that there is a provision, if a public document which can be believed without any further inquiry indicates that the accused wasn't at all on that day at that time, according to me, it may be a case for not taking cognizance. Second is a situation. Now, a private complaint is filed or a police case is filed. Let us say the accused has admitted the guilt. Some nominal fine is imposed, 100 rupees, 200 rupees. This complainant is agitated. After all, he is let off with a petty fine of rupees 100. Let me teach him a lesson. And therefore, he lodges a private complaint for the same offense. First of all, principle of double jeopardy, covered by Article 20, 300 CRPC, corresponding provision in BNSS. A certified copy of the order sheet of that case, which shows that he pleaded guilty and he has been fined, or after trial he has been acquitted, or after trial he has been convicted, certainly should persuade the magistrate not to take cognizance and close the proceeding at that stage. Well, these are all things which we'll have to think of. Right now, we can't predict what are all the situations where the court may not take cognizance after giving an opportunity to the accused. Then again it says subsection 2 is an insertion. If a complaint is against a public servant, an opportunity should be given to the public servant to make assertions as to the situation. A report from his official superior is also required to be secured. Then there is one thing with regard to trial in absentia I have completed. With regard to this 398 BNSS, it is an insertion. We have what is known as a witness protection scheme. Witness protection scheme under 398 BNSS. Every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of the witnesses. The new law is only 27-day old. The state governments are yet to prepare a scheme and then notify. It would obviously take some time. Well, is there no witness protection scheme right now? Kindly refer to Mahendra Chawla versus Union of India. Mahendra Chawla versus Union of India, 2019, 14 SCC 615. 2019, 14 SCC 615. See, in this case, the Supreme Court appointed amicus curiae, called for reports from various high courts as to how some vulnerable witnesses can be protected when they come to the court. The Supreme Court also asked NALSA to prepare a scheme, Delhi High Court, and ultimately, Witness Protection Scheme 2018, prepared by NALSA Delhi Court, has been approved by the Supreme Court. Supreme Court has said in paras 35 and 36 of the Mahendra Chawla statement, we give our imprimatur to the scheme. It shall be called the Witness Protection Scheme. That Witness Protection Scheme is almost like a statute. That entire scheme of 2018 is extracted in this judgment. Supreme Court has also said, till such time the government brings a legislation, this judgment shall be read as law in view of our powers under Article 141 of the Constitution. Therefore, even as the government is yet to prepare a scheme and notify it, we have the judgment of the Supreme Court, which has put its seal of imprimatur, that is approval, for that Witness Protection Scheme 2018. One thing in the process I forgot. There are some views expressed from some corners as to whether the special procedure for these private complaints contemplated by BNSS, which requires an opportunity to be given to the accused before taking cognizance, needs to be applied to cases under 138 of the NI Act. Those who share the view that this procedure contemplated by BNSS need not be followed are relying upon the non-obstante clause in section 142 of the NI Act. I do not share their opinion. The opinion expressed are by those who hold office. Certainly, if their opinion is approved or upheld by the superior courts, that becomes the law. My view may be upheld or may not be upheld. I have nothing to lose. But till such time, the law is declared by the concerned high courts or by the Supreme Court. Well, I am presenting my view. If what I tell can persuade some of you, fine. But it's all a matter for how the superior courts interpret this. What is this non-obstante clause contained in section 142 of the NI Act? Notwithstanding anything contained in the Code of Criminal Procedure 1973, certain things are stated. A reading of this non-obstante clause would tell us that this non-obstained clause has only 4 effects. Where do we get it? Number 1, as covered by 142(1)(a), a court cannot take cognizance except on a complaint. That means on a police report, the court cannot take cognizance of our announcement under 138. A private complaint is required. B, the complaint has to be filed within 1 month from the date on which the cause of action arises under Clause C of 138. You know that notice is given. In the notice, a period is specified within which the accused has to make payment. If he doesn't do it, then a cause of action arises. So CRPC, as I said, also provides a limitation. This limitation, you can't go by what is provided in CRPC here. CRPC says a criminal law can be set into motion by you. There are a number of exceptions in CRPC also. For an offense of bigamy, for an offense of defamation, court cannot take cognizance except in a private complaint. When CRPC was drafted in 1973 or 1898, 138 was not an offense. It was made an offense in 1988. Therefore, the framers of CRPC could not have thought of something becoming an offense later. It is not just 138 at the NI Act. We have got number of special enactments which contemplate a private complaint. So therefore, the first effect of this non-obstained clause is a bar to the magistrate to take cognizance on a complaint. He cannot take cognizance without a complaint. He cannot act on a police report. Second, period of limitation. Third, a metropolitan magistrate or a JMFC can alone try the offense, not a judicial magistrate of second class. Subsection 2 says period of the territorial jurisdiction. That again has a bearing to some Dashrath Ram case or something, where the court, Supreme Court has said where the trial has to take place. Keeping that judgment in, some amendment was brought in 142. So, the non-obstained clause, according to me, has only this effect. Number 1, court cannot take cognizance on a police complaint, having a police report, only on a complaint. There is a period of limitation, territorial jurisdiction, and only a metropolitan or a magistrate. I do not think that this non-obstained clause in 142 of the NI Act can come in the way of, can override the provisions of the new amendment. This is my view about it. There is one other view taken. The Honorable Supreme Court in Indian Bank Association case, if I have the citation right now, I will give it. 2014 5 SCC 590. 2014 5 SCC 590. Indian Bank Association versus Union of India has laid down some procedure. Some are of the view that in view of the non-obstained clause in 142 of the NI Act and Indian Bank Association case, courts need not follow this BNSS. About that non-obstained clause, I had my say. Now, with regard to this Indian Bank Association case, after hearing from people that this Indian Bank Association case has brought about a change in the entire procedure regarding 1938 offences, well, I have gone through it. The important change there is this. Now, a sworn statement is recorded before the accused enters the scene. The procedure till now had, rather, till this Indian Bank Association case was, after the case was registered, summons used to be sent to the accused, whether it is 138 or any other case, accused would appear. Then whether it is a summons trial or a warrant trial, actual trial used to take place. Now in this Indian Bank Association case, the Supreme Court has said that sworn statement recorded itself can be treated as examination in chief. In reality, it is so, because there, in fact, if we carefully read that provision, it says, 145, evidence of the complainant can be taken on affidavit. It is not sworn statement, but courts have interpreted when evidence during trial itself can be taken an affidavit. Why not sworn statement? It stands to reason. I have a problem with that. Now the Supreme Court has said that evidence referred to in 145 will have to be taken as examination in chief. Directly, the accused has to be called upon to cross-examine. There is no question of the complainant again entering the witness box. This has been done to expedite the trial. There is some view that 313 CRPC statement can be dispensed in view of Indian Bank Association case. That doesn't happen. Karnataka High Court has clarified it. Since I am speaking to lawyers of all states, there is no need to refer to the Karnataka judgment. Officers of Karnataka may be knowing it. Now the question is, according to me, this 142 of the NI Act or that Indian Bank Association case will not come in the way of the court doing it. The last section and the last thing I will have to tell is repeal and savings. With a hope that whatever is now told by me is not repealed by the audience. And it is saved on the other hand in their memory. May I hope that whatever I have said will be repealed, will not be repealed, and it will be saved. Now, what is this repeal and savings? As I said, there are different opinions. I am giving a literal interpretation to this 531 BNSS. I can only persuade you. The Code of Criminal Procedure is hereby repealed. 5. Subsection 2. Notwithstanding such repeal, if immediately before the date on which this Samhita comes into force, that is before 1/7/2024, there is any appeal. Appeal is filed under 372 CRPC. Application 317 CRPC for exemption, 309 for recalling. Number of applications 91 CRPC. Trial, inquiry, or investigation pending. Then such appeal, application, trial, inquiry, or investigation shall be disposed of, continued, held, or made as the case may be, in accordance with the provisions of CRPC, as in force immediately before such commencement, as if this Samhita had not come into force. The clauses B and C are not necessary for our purpose. Now there is a view. If the offence is committed before 1/7/2024, investigation would have commenced under the CRPC. There is no question of applying. Where do we get this word offence? Anywhere in 531(2). It only says if any application is pending, trial is pending, inquiry is pending, or investigation is pending, it shall be continued under CRPC. In this regard, views are divided. Punjab and Haryana High Court, I had that decision, now I have. That's not opening. You find it out. If it is still available, I will make it available to you, because he will be more aware of that Punjab and Haryana High Court decision than me. So, Punjab and Haryana High Court has endorsed my view, saying, according to me, if an application is filed on or after 1/7/2024 for exemption, for recalling, or for summoning of documents, or an appeal is filed, or a revision is filed, anticipatory bail, regular bail, all that according to me, irrespective of the date of offence, irrespective of the date on which the investigation has commenced, irrespective of the date on which the trial has commenced, irrespective of the date on which criminal case is registered, the provisions of BNSS will have to be mentioned. Punjab and Haryana High Court has taken that view. Rajasthan High Court has taken a different view. Kerala High Court in criminal appeal 1186 of 2024. Kerala High Court in criminal appeal 1186 of 2024 decided on 15/7/2024. 15/7/2024. Abdul Khader versus State of Kerala. It's also available on 2024 live law, Kerala 450. 2024 live law, Kerala 450 has taken the same view as Punjab and Haryana with some change. What the Punjab and Haryana High Court said is, if the application is filed mentioning the provision of CRPC after 1/7/2024, that would not be maintainable at all. But Kerala High Court said we don't go to that extent. Though we also take the similar view as the Punjab and Haryana High Court, that the application or appeal will have to be filed mentioning the new provision under BNSS. The same application can be treated, same application where the provision of CRPC is mentioned, can be permitted to be amended to mention the new provision under BNSS. Certainly, because all of us know it, mention of a wrong provision or non-mention of a provision is not a ground to reject the application at all. If otherwise the relief could be given to the plaintiff, defendant, accused, complainant, or if the otherwise the court has power, mention of a wrong provision will not come in the way. So this is my view. I leave it to the audience to have their own view. All that, of course, subject to the view, the opinion, or the law laid down by your respective high courts. Thank you. Nothing more. Again, the same thing. Whatever is stated will not be repeated at your hands. It will be saved. Thank you. Any questions? Well, there are some changes here and there. I have not touched them. I have seen number of lectures by people more qualified than me, more adapted criminal law. I was also hearing to some of them. They have made very good presentation, and it's all available in YouTube. So as and when you have got time, you can listen to them. Yes. Any questions?
I've also done few sessions on the different perspectives.
Yes, yes.
We have done with Justice Mukta Gupta. We have done one
Yes.
with Ragnar Bramkar, one we have done with Prachu.
Yes,
So we
number of. But I also just heard one of them yesterday, today, before your session. I could not complete my listening to it. I will have to carry forward. Some good presentations have been made.
Yes.
Well, please.
I've seen that there are no questions. Thank you for sharing your knowledge. Thank you.
Yes.